Hi.
Good morning. I'm here on two cases. The first one's on the docket, Malveau, Malveaux. Judge, this is the one we approached, and I've been back a couple of times trying to amend the condition for the mom. This is an alleged assault, family violence between a mother and a son. Ms. Malveau is here. The state has agreed, and I think they've contacted someone to change her bond condition to, we were just going to ask to allow for the texting and the phone call, and then you would ask them to do some follow-up rips.
So the defendant is mom,
Yes,
complaining witness's daughter.
this is the, I believe,
Daughter's
15.
21 or 20?
Son,
The son is, he's 18, I believe he's a senior in high school. He's living with a family friend right now. And we are okay with amending bond conditions to allow communications over cell phones. They can still text and call. But we would ask the court to hold any in-person contact.
and Judge, we would ask to allow her to go to his sporting events. No contact with him there, but she'd like to go watch him at track.
No, I mean, it's
And
invariably
football.
going to happen where she's going to get overcome with emotion. Then she's there. He's 2 feet from her.
Then she'd be
Know what I
on the
mean?
field and she'd be in
It's
the
like-
stand.
It's like holding a candy in front of a baby. I'm sorry, not a baby, but like a 13-year-old kid.
Judge,
you
I
know?
believe she could stay in the stands. And
Malveau, come up.
And he'd be on the field, but
I don't know. I mean, I don't think that's
Jose Montes?
it's setting up for Kelly right now. The only thing I want in the short life while I'm here is to protect every single complaining witness in these cases, in this county, in this state, as much as I can. And the problem is that temptation is so very high. We have at this moment a no contact order. You're not supposed to have any contact with this person. Your lawyer's asking for me now to allow you to have contact and texting privileges so that you guys can have some kind of communication. The state is still opposed to having you in-person contact. And the problem is that if you go to, and I'm inclined to, agree about in-person contact. The problem is that if we allow you to go to these sporting events and he's 2 feet away from you, the temptation is so high, it's invariably going to happen. And we're not there to see whether it happens or not. And so therein lies the problem, is that I will never be able to monitor the fact whether you actually have contact with this person or not. And that's a problem, because the last thing I want is you to pick up more cases or this person to get more hurt.
talking about in person. Y'all have him as 18?
We actually have them in the updated record page 16.
Yes, Judge, he's 16. He's not 18.
The birth date was listed
It's
wrong.
okay.
And his father's in jail.
Remind me about the assault, please.
Sorry, Your Honor.
Refresh me about the assault, please. Not bad.
So, yes, Your Honor. So the assault took place in June 2024, and the victim was identified, and the victim explained how his mother, the defendant, assaulted him by biting.
Biting.
Yes, Judge. You see. So the victim stated his mother was angry that he was in the way, and as he was holding her two wrists, she raised her hand up to her mouth and raised his hand up to her mouth and bit his hand. The victim stated he felt pain, was in fear, and the victim had a visible bite mark on his hand.
Judge, the son is holding her first, just so we're clear on what's up.
I mean,
Yeah,
Yes,
no,
it does
he's
state
not
that.
quite saying that.
Well, it does
I
state
mean,
fully
what
that
circumstances happen to where a 15-year-old grabs mom, right? I mean, perhaps they were fighting, I don't know, but the fact
Judge,
remains is that
there's been no facts and nothing in the probable cause that I've been given or that I've shown that any of this was between the mother and the son. I believe it was between my client and another lady, and the son comes and holds her. I believe that's what the
So-
facts will bear out.
he's trying to protect her. He's trying to, I guess, de-escalate the situation.
Judge, I believe that those would be facts that I would want to
Right,
try,
I mean,
yeah.
I don't know, and so, right, same thing, I mean, regardless, what we
facts
do know,
I'd want to bear out, but it's not like she just walked. I didn't want when you're making your decision for you to be basing it on, what it sounds like she walked up to him and bit him. That's not how it happened.
I get it, thank
Thank
you.
you. Thank
Because,
you.
and, I mean, the idea is that we really want to know under what circumstances everything happens. That's why with every case that we have here, we really delve into it as deep as we can to determine, is there probable cause? What circumstance should we have as far as contact or no contact? Guys, what do you think?
Judge, we're okay with them texting and calling each other to catch up.
What does he want? I mean, at the end of the day,
So
we need to find out what he
It's a little bit of
wants.
a complicated situation in terms of the complainant's guardian, because he is 15 and said he's living with a family friend. What we do know is that he does not want, to be living with the complainant, with the defendant. He wants eventually, I think his essential goal is to get emancipated. We do know that, we talked to the person that she's living with and says that they have been texting already. So because of that, we're okay, and that they're
Be
okay with
texting her
it.
in violation of a no contact order. If that's the case, I mean, I've got it. We'll take issue with that.
So, this was based on the talking to this parent. She wasn't entirely sure.
Do we have a no contact order now?
I'm not. Not entirely sure. And the other thing is that we haven't confirmed that with the complainant itself, with 15-year-old, so at this point, we don't have evidence to imply
Right.
violation of a corrective order or anything at that point. But it seems like the kid is okay with calling and texting, but hasn't.
But you don't know that for sure, though. You don't know that for sure, right?
That's correct.
And Judge, as of December 18th, 2024, there was a no contact order in place.
I hope that you're not having contact with this
I'm
person.
not having.
I hope. Just, let's do this. Why don't we set this off for a couple of days? If you could please reach out. I want to know what he wants or she wants.
Judge,
In parent school is really hard.
I want to honor the complaining witness's wishes.
with,
This is that they just don't know.
well, Judge, can I just recount this? We've been asking them to know this. This is the very first time I was appointed, I approached you on this. You asked them the exact same questions. They've done nothing. They can't get in touch with the complaining witness. I came back on February 2nd. I came back on February 3rd. I came back on February 10th. I came back on February 11th. I came back on February
I mean,
12th.
I agree with her. That's kind of, that's,
And that's why it's important are agreeing to have that whole section, which is what.
but you still don't know.
We have talked to the guardian, we just haven't been able to talk to the kid. The legal guardian is an aunt who does not live with the complainant. We're talking to her as a family friend, we've talked to her, we've given her multiple calls.
So,
We just haven't been able to get.
so let's do this.
Judge,
Let's-
that's a misstatement. The sister's not the legal guardian. The son is living with a family friend right now. His father's in jail.
The complaining witness is a boy or is it a girl?
He's living with a
It's the boy.
schoolmate,
A
Judge.
school, a friend from school.
He's living with a friend from
His
school.
dad dropped him
And she's
there
gonna do a
and went to
BIP. The
jail.
chief has offered a BIP and dismiss.
I get it. I understand.
A BIP and a parenting class. Sorry, he did tell me that, Judge.
I understand, but I always want to honor the complaining witness's wishes, right? So let's do this. I do find it unreasonable that they've been here as many times as they have, and you guys have been unable to do this. So what I would suggest is do this. Reach out to them and say that we're going to subpoena them to come to court if they did not get in contact with you guys. Because I agree with you that it's unreasonable to have to come back 4 or 5 times just to see. So let's set this off maybe like 3 days, 4 days. Reach out to them and say, hey, we are going to subpoena you to come to court. If you guys, all we want to know is what's going on and whether you guys want to have contact and in-person contact as well. So ask everything so that you guys don't have to come back. Anticipate every single question that they're going to want known. So that you can.
Yes, Judge.
So what we can do, so you don't have to waste your time coming to court. We can set it off 3 days, 4 days, and I'll waive your next appearance so you don't have to come here. And then she can reach out to you, phone, because I don't want you to have to miss work or whatnot or anything. But I have to know what they want. And I don't want to work on speculation because
Is it what my son wants or is
it's
it?
what the son wants. I don't care what the guardian, I don't care who the guardian is. It's what the son wants. Right. I don't care about a guardian. It's not their decision. And I think that now, 16?
16-year-old.
He's old enough to know, right? He's almost an adult, so he's old enough to make decisions on his own at this point.
And Judge, I've already accepted the PTI. We will get started on that. So even by this next setting where she doesn't have to appear, excuse me, Judge, she'll already be underway on the PTI.
Okay. And the parenting class is probably pretty short, so it's,
It's BIP and parenting classes, Judge. I'm sorry.
what is it?
It's BIP and a
Oh,
parenting class.
BIP and a parenting class. Okay.
I'm not really sure. I've got to figure out how long they want her in BIP and talk to her about that.
Got it.
So
Okay.
you can go sit down just for a second, then we'll get your case reset, okay?
Okay.
All right, we'll keep trying. Judge, I have one other one on docket today, and it's just a reset, and I've just been appointed today. Do I have to approach you on those? You've already found probable cause. It's Mr. Hall falsifying the drug
No,
test allegation.
no,
All right, then I'll just.
Just let him know that he's going to get drug tested about 50 days. Just so he knows, and that's it.
Thank
Okay,
you so much.
thank you, Mr. Chair.